And so his sort of policy purpose here is to increase flexibility in order to give the government effective tools to respond to terror. And it's not just torture that he thought was important to be as a tool for the president. He also authored a memo that said the Geneva Convention should not be applicable. In other words, we should exercise the authorities of war without being governed by the rules that go with the authorities of war. He also authored a memo saying the president, without any authorization from Congress, is free to use military force to attack any terrorist anywhere in the world, regardless of whether it had anything to do with 9/11 or not. And we think he was the author of the memo, which has not yet to be released, but which authorized the president to tell the NSA to engage in warrantless wiretapping, despite a federal criminal statute that prohibited that. And all of them are predicated on this notion that the president, as commander-in-chief, when he engages the enemy, cannot be constrained by any other any laws, whether they be international laws, whether they be statutory criminal laws, or whether they be constitutional restrictions. And I think that kind of argument fed a desire on the part of the administration to be unchecked, and it's an understandable desire on the part of any administration to be unchecked. But this administration took it very far, and I quote at the end of my essay a sentence from the Bush administration's 2005 national security strategy, which I think really captures the John Yoo vision made formal policy by the Pentagon. It reads, "Our strength as a nation state will continue to be challenged by those who employ a strategy of the weak, using international fora, judicial processes, and terrorism." Now that is a remarkable statement, because first of all, it dismisses the rule of law, right, judicial processes and international fora, as a strategy of the weak. That's not for us. We're strong. It's only for weak countries that need that. But more astoundingly, it associates the rule of law with terrorism. Now, I would have thought that when we got attacked by people who had disdain for all principles of law, all principles of human dignity on 9/11, that the rule of law would be on our side. Right? The rule of law would naturally be on our side as the victim in this attack. And yet 5 years later, the official position of the Pentagon is that the rule of law is on their side, not on our side. Now, I will say that I think, just to conclude on a somewhat more hopeful note, I think there has been a significant retreat on the part of the administration since the days of John Yoo. John Yoo, by the way, has not retreated. He is out there. You see him. He defends every one of these policies to the max, and he's outraged that the Bush administration has retreated in his absence. But it has retreated. It's retreated on torture. It's retreated on cruel, inhuman, and degrading treatment, which it initially took the position didn't apply to foreign nationals outside the United States. It's retreated on Guantanamo, where it initially took the position that they didn't deserve any hearings whatsoever and could be interrogated inhumanely. It's had to retreat on military tribunals because the Supreme Court ruled the military tribunals illegal. It's had to retreat on the Geneva Conventions because the Supreme Court said the Geneva Conventions applied. And it's retreated on the NSA program after a lawsuit that Beeson and the ACLU filed reached a ruling that the NSA program was unconstitutional, and the president, while appealing, also announced that actually he was terminating the program because it turned out that he could do all the surveillance he wants without violating the law. And I think that's significant, that on virtually every one of the administration's sort of initiatives, it has been forced to retreat, not to the point where I'd like to see, but significant retreat. And I think that suggests that at the end of the day, the rule of law may be more powerful, and the United States may be less powerful than many people probably thought on September 11th. Thank you.
Good evening, everyone. Thanks for being here. My essay in the book is called The Secrecy Trump, and I'm going to talk a little bit tonight about the government's use of secrecy as one of its most powerful tools in the backlash against human rights in the name of national security. In a number of court cases that challenge a whole range of abuses in the war on terror, the government has imposed routinely gag orders on both clients and on lawyers, and many of these federal gag orders were imposed years ago and are still in place. They routinely introduce secret evidence, which to support their legal arguments, which most of the time the lawyers are not even entitled to see. They call for closed hearings, again, sometimes without the presence of plaintiff's counsel, and they have more and more routinely invoked a dangerous doctrine, which I'll say a little bit more about, called the state secrets privilege, to argue that a range of different lawsuits challenging these abuses can't even be heard by the courts. In other words, the courts lack the power to decide whether or not these practices and policies are constitutional. What they're essentially arguing, and what they continue to argue, is that secrecy is so essential to our safety that the legality of these various policies, from rendition, illegal rendition, to wiretapping, cannot be reviewed by anyone. Now, that's a very dangerous policy, and in fact, I've come to believe that secrecy is almost as potent as fear in getting the government what it wants. That there's something about this argument that it makes that secrecy is always necessary to protect our safety that causes this knee-jerk, abandonment by the courts and by Congress, frankly, of their duty to serve as a check on executive power. It's become a very powerful tool, both for stifling public debate on a range of issues, for hiding abuses, and I unfortunately remain convinced that there are probably many other programs and policies that we still know nothing about because of the lack of transparency of this administration. And it's been a powerful tool, as I said, for thwarting particular legal challenges to abuses when they do come to light, primarily through whistleblowers who sometimes take great risks to come forward and let the public know about these abuses. I'm going to give just a few examples from my my work, my litigation practice at the ACLU, just to give you a flavor of what these arguments look like. And for the first example, I want to go back a couple of hot summers ago to August of 2005, when many of you may recall that the nation, or at least part of the nation, and certainly D.C., was very engaged in a lively debate over reauthorization of the Patriot Act. And the government itself had gone on a very strategic kind of dog and pony show all over the country. U.S. attorneys, all sorts of administration officials were traveling the country to convince people to support reauthorization of a number of the expansive surveillance powers of the Patriot Act. And what became one of the hot button issues in the debate was whether or not some of these new powers to obtain personal records without court approval were being used to obtain library records. The American Library Association and a number of librarians all over the country have become very concerned and have become very active and opposed to the Patriot Act. And John Ashcroft and Ben Gonzalez and many others had poo-pooed these concerns and said, we're not interested in library records. We aren't using the powers to obtain library records. Well, about that time, in August of 2005, I got a call in my office at the ACLU from a quiet little voice in Connecticut, and it turned out to be a man named George Christian, who was the director of a consortium of libraries in Connecticut. And George Christian had received a national security letter from the FBI